Hi, and welcome to Stencil TV. You're here today with me, Mulibi Mapayane, the COO of Stencil Technologies. I'm joined by my partner and co-host, CEO of Stencil Technologies, Ohone Mutwahai. We're joined today by Senwelo Modise, the partner and head of technology and media and telecommunications for Botlhole Law Group. Today we're talking about the Data Privacy Act. Is that right?
Yes and no.
Okay.
Yeah.
Well, it would deal with privacy. It's an extension of privacy, but if you deal with Botswana, you'd call it data protection.
Okay.
Because data privacy is an American concept. So it's something you talk about when you are talking about Canada and the United States or even South America. But for Botswana, for Africa, for the European Union, you'd find data protection.
Okay.
There's something fundamentally different
Yes,
with the terminology.
what is fundamentally different would be the origins, the history.
Okay.
The data protection's history, you would relate it to the Council of Europe. 1981, what we would celebrate today as Data Protection Day on the
Right.
28th of January
Yes.
every year. But with data privacy, it is more to do with the privacy of data. Data protection is the privacy of individuals. So that is where the difference is. The confusion is always, well, with data privacy, you are talking about protecting data from unauthorized access and all the like. But with data protection, it extends more than that. It deals with the individual and extending the fundamental right to privacy. To say not only do you need to protect the data from unauthorized access and unauthorized modification, you need to give this person rights. This person needs to be able to give effect to their right. This person needs to know what is happening to their data.
Right.
You need to inform, you need to be transparent. So you'd say that the manner in which data protection has evolved, you would see from the manner in which the GDPR is a bit more stringent than any law that is in the US or in Canada.
Yeah.
So data protection really is about extending fundamental right to privacy.
Yeah.
So it's protection, not privacy. Right?
It's protection.
It's protection over and above privacy.
Yes, it's protection of the individual in
Yeah.
relation to their right to privacy. Because the right to privacy has evolved over time. When it started, it was more about not being intruded in your personal space, not trespassing,
Yes.
being allowed to be secluded. But then information technology came. We were able to process vast amount of data, and now people need to be protected in relation to their data.
Yeah.
Yes.
Cool. So who does this really apply to? Like, who needs to be concerned about this Data Protection Act?
Pretty much everyone. Pretty much everyone. Even here, Stencil Technologies needs to be concerned about it, because for as long as you process, and by process we mean anything that you do to data, as long as you process personal data of an individual, then you need to be concerned. And by personal data, we mean data that identifies an individual.
Okay.
So if you think about anything that identifies an individual, directly or indirectly, then you ought to be impacted by the act.
So what is that? What does that look like?
So and maybe you can help me if I'm going wrong, but there's this idea of the PII, which is the personal identifiable information. So as you go through your daily life, you're creating this footprint of digital data. So it's like a car emitting fumes, but these fumes are literally zeros and ones.
Yeah.
Right. So now some of this data can identify you directly. So your ID number, your name and surname, your blood type, your DNA, all of that stuff is personal identifiable information. So
Email address. How often
to a certain extent.
We just put our email address in so many different places, right?
and the reason that is you can trace an email address back to a whole host of other personal identifiable information.
Yeah.
If you just pull a few triggers from a text perspective, you can actually get to a point where you can actually unscramble the email address to actually give you
Who is this individual?
who your mother is.
Yeah.
You know what I'm saying? So that's personal identifiable information. So I think that's the one that these acts are really more concerned about.
Yeah, but just to add on to him, that's also one thing to pay attention to, Because what is personal identifiable information, what is personal data, is defined by the statute that applies to you.
Okay.
You talk about personal identifiable information if you're in the US.
Yeah.
But you talk about personal data if you're in the EU or in Africa.
Elsewhere, yeah.
The only difference is that what the Act restricts personal data or personal identifiable data to be. Personal identifiable data, it's more relatable to the Health Insurance Portability Act of the EU, which is the HIPAA. That is where personal identifiable information was defined. But if you consider our legislation, it says personal data. It has no personal identifiable information. But they mean the same thing. They mean information that identifies an individual, except in one jurisdiction it's called one thing, in another it's called another thing. But when you talk about personal data, directly you can think of someone's name.
Yeah.
Indirectly you can think of someone's internet protocol address. Indirectly you can think about your plot number. Well, your plot number on its own doesn't say much, but if we relate it to something, say plot number 1111 at partial, if you go look at SIPA, it can identify you.
Correct.
Exactly.
But as long as you are able to discern who this individual is,
that becomes
that becomes it. But then that would be the material scope of the legislation.
Yeah.
Yes, what it relates to. What ultimately decides whether or not you need to comply is the territorial scope.
Okay, territorial scope.
Yes.
So I want to go take us back a little bit.
Okay.
Right? Because you think about it, how many of us order food online, using an application or anything like that?
Yeah.
Or even just somebody's side hustle, where they're delivering food to you on the side. They're keeping your customer data. And they kind of have to be aware, like, does this apply to them?
Yes, when we talk territorial scope, we mean the jurisdictions, or should I say the countries, the territory where the Act applies.
Okay.
If you look at our Data Protection Act, the one which commenced on the 15th of October 2021, it is such that it will apply to what we call a data controller, a data controller being the person who's processing the data. Whether the person is a natural person or a company, because companies are a type of persons.
Yeah.
It would be a data controller in Botswana. So if it's entered into a file for someone in Botswana, and that's also important, entered into a file.
Okay.
If you process but you're not entering into a file, the Act may
What
not
does that
apply.
mean, a file? Come on, are we talking about a manila envelope?
Okay.
Now, or what do we say?
She's a lawyer. Open a file. Right?
Yeah, she's trying to get me to pay a deposit now.
When we say entered into a file, now we are going to information management systems,
Okay.
information
see.
technology.
Create a record.
Yes, if you keep
Yeah.
something in a USB, it has a filing system.
Yeah.
Isn't
Yeah.
it?
Okay.
Yes, and there's FAT32. That's
Yeah.
a filing
Oh, there you
system.
go.
Yeah.
Yeah.
NTFS. That's a
Yes.
filing system.
Yeah.
So if you can keep it in something where there is a filing system, just go for filing system from the
But my
perspective.
WhatsApp chat is a filing system.
It's a filing
It is,
system,
yeah.
So if it's entered into a file,
Yeah.
that is a filing system
Sure.
for someone who is in Botswana,
Yeah.
then it applies. And if it's entered into a file for someone who's not in Botswana, but uses processing means in Botswana, then it would also apply.
It
What
applies.
does that mean, processing means?
Yeah.
I'm going to go to him on this one.
So the processing means is how you pull the data and you can actually utilize it. But you see, it gets a little murky, and I'm going to throw a pigeon a cat among the pigeons here for you to say,
It's a little.
even the personal identifiable information, or the personal data, you say it's called in the EU space, is a little gray, because what companies tend to do is now bypass all these data protection acts, and they do this by because they know that, say, the GDPR or the Botswana Data Protection Act will not allow you to share personal identifiable information. So you take the data, strip it of personal identifiable information. Then it's unidentifiable. It's anonymized, if you like, right?
Yes.
Then they take that data and they can on-sell it to third parties. Now, in that way, they haven't, strictly speaking, broken the Data Protection Regulation Act, or whatever you want to call it. Depending on how you're a lawyer, there's probably ways to say, oh, we've taken this out, so therefore it's anonymized. It doesn't apply. But from a technical perspective, there's so much other data in the world from social media that you can actually use as a baseline, if you use artificial intelligence as an example, to reconstruct and rebuild that data, to identify to a very good degree of accuracy who this individual is, and then on-sell it. But by that time, it's on the third person out.
Yeah.
You see what I'm saying? So, but the person or the controller that took it has actually not broken any data protection laws. So, in that context, do we have a sense, and with the eye that you have as a legal person, do you think we have a position there where we're avoiding that gap?
Okay. I think one of the things we should take cognizance of is that the Act is seeking to protect people where they are identified.
Okay.
If they are not identified, then they suffer no harm. If at all someone is to have unauthorized access and cannot identify people's data, there is no harm to the individual. The data protection laws are not trying to hinder people from making use of data.
Yeah.
They're just trying to protect individuals from being harmed. Now data be in the wrong hands.
Yeah.
So anonymization and pseudonymizations are one of the ways in which you can ensure that you make use of data for business, for whatever reason, without risking individuals being exposed to harm.
Okay.
It's allowed in law. If you anonymize, it means you have to use privacy-enhancing technologies that make it impossible to reverse or to identify, to re-identify at some point.
Yeah.
But if you pseudonymize, then it means the data may be re-identified at some point. Each and every data controller in the value chain of data has obligations. You who collected it first, you who it goes to second, or who it's disclosed to.
Yeah.
But each and every one of them has obligations. And if you find yourself with data that has been re-identified, then it doesn't matter whether the data controller who first got it had anonymized it. You have to like comply with the law within the data that you have had. I'll give you an example. Facebook is a data controller on their own. They collect that data.
Right.
Any company that does marketing derives publicly available data from Facebook, is a data controller. They have to justify their basis for processing away from Facebook. They can't use the same reason that Facebook used.
Right.
They have their own. So the company that they relate with, that they may share the data with, also have to justify it. So each and every controller in the value chain of data has to justify.
Okay. Let me ask you this.
Yeah.
If I take, and I want to give you a practical example.
Okay.
So I can take personal identifiable data, strip it of everything, and on-sell it, pass it on. Let me not say on-sell it.
Yes.
Pass it on. And then I pass it on to Mulibi. Mulibi uses whatever means he has to reconstruct it. And there's a lot of ways you can do it.
Okay.
You can strip data of everything in the world, and I can use other data. Literally, you can strip. If I take your Fitbit data, and I strip it of anything Senwelo, I can go elsewhere and see and do a mapping of who is this 1 in 7 billion people who runs down the route of Tlokwen down this place and has a heart rate of 78 beats per minute, and wakes up at 6 a.m., goes to bed at 8 p.m. I can literally narrow that data set from 7 billion people to one person.
Sure.
Does the Data Protection Act protect individuals against that sort of thing?
Yes, it does. The data controller who does the act of re-identifying then now will have to comply.
And would have to be able to justify why they're doing that. And is that in the best interest of the individual whose data they are processing?
But the point I'm making is it's almost backwards. So they didn't start off with the identifiable information.
Yes,
they're going back to it.
Yes, this is how it would work.
Right.
The data controller who first collected it would have a legal basis for collecting it.
Yes.
And if you look at the act, it prohibits what we call further processing. So further processing is I've collected it saying that I want to give you a service. And if I disclose it to someone else, that is disclosure in itself is processing.
Yeah.
Transmitting is processing.
So when you said any processing in Botswana, it's transmission, it's storage, it's
everything.
Anything with that data.
Yes, it's cleaning it. Just anything you do to the data is a form of processing.
Okay.
So disclosure would be a form of processing.
Right.
So at the instance of disclosing, the company that first collected it is not breaking any law because it's disclosing data that is not identified.
Right.
But the data controller who receives it, in re-identifying it now, makes themselves fall within the purview of the ambit of the Data Protection Act. So
and they have to justify
then they
their
have
reasons.
to justify. Now you have re-identified. You are handling data that is identified. That's identifying people. Now then comply with the law. It's different than if they had worked on the data when they didn't identify anyone. If you don't identify anyone, you can do as you please with it. But in the instance of identifying it, now then comes having to comply with the act. And the challenge for the company that re-identifies is, if you look at Section 29 of the Act, it says, if at all you are obliged to notify or to inform an individual as you collect data directly from them.
Right.
And you also have to notify them or inform them when you collect data indirectly from them. Now then you'd have the hassle of informing people you didn't collect data from directly. It's a business consideration you have to think about, that if I re-identify, what is my cost of informing?
Yeah. What about if somebody gives you, for instance, if somebody's using a platform, it's anonymous to us, we don't know who's on that platform, right? What is our obligation there? Now I'm talking about ourselves now as Link SMS. Someone's using our platform, sending messages for themselves to third parties. What is our obligation in terms of telling people, well, somebody stored your phone number here?
Yes. First, you need to identify which of in the act are you then the data controller or you are the processor? Okay. So a data processor would be any person that processes on behalf of the controller.
Okay.
So I guess as Link, if someone gets your service, you are doing something on behalf of someone. You would have been instructed. So then you need to look at what your obligations are as a processor. Does a processor have to inform?
Yes.
So who regulates all of this?
It would be the Information and Data Protection Commission, an office, a public office that has been created by
here in
the
Botswana?
Act. Yes, here in Botswana. Yes.
So is that office operating? Is there a commissioner yet?
There's not been a commissioner announced yet, but I think the government is in the process of setting up the office, considering that we're left with 8 months before the lapse of the transition period.
And that's October.
Yeah, that's until October.
And so I just wanted to take you back to that re-identification. So what if you can reconstruct data and re-identify it only up to a demography level? So youth.
Yeah, age groups.
If I have 3,000 terabytes of data and all I just want to know is people who are 18 to 25 in it, and I know I can sell them something.
Okay.
Do you call that identifiable?
18 years on its own is not identifiable. So if at all whatever processing activity you do, you find that if you were to ask the question, can I see who this person is from just seeing this data, then you don't have to.
But you see, this is where I was saying the line is very blurry, because if all you need really, I mean, I don't think Cambridge Analytica needs to know that I'm from Kanye. They just need to know my political views. They just need to know that I'm of this age bracket. So if that is permissible, I think that the line gets very gray. And there's a lot you can do with that sort of data.
When it comes down to data privacy versus data protection, right? So what is infringing upon your individual rights to anonymity and to the right to be forgotten, and a whole bunch of different things. So as long as they are not able to pick up, point and say,
this is him.
Then it's fine. And that's what I'm picking up, right?
Yes, but then you also have to note that you can identify indirectly. So you can have a set of data. Say you have 4 data sets: age, where someone lives, what someone likes. Those things may not be the name, but they can tell you who the person is. If at all you can arrive at who the person is, then it's identifiable. But if the data can't get you to a sensible conclusion as to who someone is,
of a living person,
which is why
or not living.
you'd need certain assessments. These assessments are not pronounced in the Act, but as an expert in the area, I know what would need to be done. For example, one, if at all you are looking to carry out a project and you think there may be personal data, and that project may infringe upon people's rights, you carry out a data protection impact assessment. The impact assessment will tell you that this data that you'd have. So the impact assessment is a multi-stakeholder process. There'd be a lawyer like me, there'd be you, the tech person who tells me what are you intending to do with this. And then we find out what are the categories of personal data that we have. Is it just personal data? Is it sensitive? What are the categories of the data subjects? So is there minors? Is there employees? Is there... Yes, you define that. What are the processing activities? Is it just going to be collection? Is it disclosure? Is it analysis? So the data protection impact assessment will define all of those things. What are the organizational and technical security safeguards that you intend to implement? And then at the end of the process, you would identify whether it complies with the data protection principles. That is one, whether it's lawful and fair, whether purpose has been clearly specified, whether purpose can be limited, looking at the parameters you have set, whether transparency is achieved. And then you then realize if at all you need to comply with the law, to what extent you need to do. So those assessments need to be carried out. If you want to transfer data outside, there is also transfer impact assessment, which help you define what legal mechanism are you going to use to justify your transfer cross borders. Yes, you have legitimate interest assessments where you want to use you don't want to use consent, you don't want to use contract, you want to use a legitimate interest. If you're a marketing company, for example, or even Facebook, they've used legitimate interest where they say, you don't consent to us using your data. We are serving a legitimate interest, which is business. We are a marketing, we are an advertising company. So we're going to process your data on the basis of legitimate interest, and we have ascertained that this legitimate interest does not outweigh your rights.
Is the legitimate interest what governments use to override most of these?
No. The governments also have a specific legal basis under the Act. If it's sensitive personal data, there's a certain provision in the Act that they will comply with. If it's not sensitive personal data, they also have to justify it. Can be consent. Literally at all times you could use any of the legal basis, from consent, legitimate interest, protecting the vital interests of the data subjects. For COVID, for example, we were doing contact tracing to protect the vital interests of the data subjects and the other people. So it's not always the case that the government uses a legitimate interest. It's a decision that has to be made after ascertaining the type of processing that you'll be doing and the type of data that you'll be dealing with.
So legitimate interest would be like, from a government perspective, I don't imagine government would want to, even after enacting the Act, I don't think they would want to wait for criminals to consent to being listened to while they are planning a robbery.
Well, it really depends. There's also another legal basis, complying with the legal obligation. If you have an act that says you can do something, you are complying with the legal obligation. Take Financial Intelligence Act. You don't need to consent to KYC. You can rely on legal complying with the legal obligation. So it's not always. That's why it's important. Most of the violations of the Act will come from picking the wrong legal basis.
And someone has to come to that conclusion.
Someone has to come to that conclusion.
And for now, it's going to be the commissioner. But then, if you want to take it to court, it will end up being
no. You as the commissioner's job is to decide whether you have picked the wrong legal basis post the fact.
I see.
Prior to that, you need someone like an expert and the team
to guide
to decide what the legal basis is. Yes, so that's why you see in the Act you have to keep a register of all your processing activities. And for all those processing activities, you would have picked what the legal basis is.
So, okay. So you don't have to engage in any way, shape or form with the commission prior to, if there's no issues whatsoever, right? So basically you just have to comply.
Well, I mean,
you're gonna meet the commission if you breach and there's a complaint.
Because they're actually asking you to communicate to them what your processes are.
And what do they do with it? Because
How are they handling this data?
So if I think about it practically, right?
Yeah.
So we're at zero base. Call us zero base right now,
Okay.
right? How many companies are there in Botswana? 1 million. Call it, right?
Okay.
Every one of these companies, including the lady that sells sweets outside, you know, including the lady that sells me quick airtime, who's taking my actual cell phone number and sending me quick airtime. That's identifiable information.
Yeah.
So you're telling me that the commission will be able to help each one of these companies to be compliant? I mean, how much work is that? So, and that's why I was
That's a
saying,
good question. I mean,
perhaps it's a question of, it's like any law.
Yeah.
I don't apply to the police to
turn right at the stop sign.
turn right at the stop sign, right? But I'll get in trouble if I don't
Well,
turn right at the
yes,
stop sign.
that's how it is. It's the
So is that how it is? So you just gotta be compliant.
You just gotta be compliant.
We don't want to have to deal with
you.
You
Don't want to have to deal
Don't make
with
us
you,
want to
yes.
have to deal
But
with
there
it.
are instances where you may need to.
And maybe we might do an audit and say, just give us your stuff. Let's see how compliant you are.
But that's not what the Act says. The Act says it is upon us.
You have to apply to.
Yeah, it is upon us to communicate to the Commission that we are handling data, and this is how we handle data, and this is, you know, this is who our controller is. These are the processes that we're handling, and this is our reason for processing this.
It'll be interesting to know how that gets handled and how long the approval process will be.
It's that, but it's slightly different. Your obligation is to keep a record of the processing activity, so that when you are asked,
you can produce
say
it.
something.
Yeah.
But there's instances where you will have to interact with the commissioner. For example, one, if there's a breach, you have to notify.
Okay.
Two, if at all you are going to be engaging in an automated processing activity.
What processing activity is
wholly or
automated?
partially automated.
Yeah.
What processing is an automated?
If you think AI, it's
Yeah.
automated.
Yeah.
So if you think business intelligence, maybe automated. But where
Everything is automated
decisions are going to be made by the machine,
Ah.
then you may have
So
to
those
interact.
those touch points you need
Yes,
to be able
if
to
at all you are
highlight
going to
them.
decide on the basis of a machine, if the machine is going to decide, then you may have to notify. You will also have to notify, if at all, after you carry out data protection impact assessment, you realize that the risk is too high. After you carry out, because
But
a
the
data
risk to
protection
who?
impact to the individuals.
Yes.
It's always about the
It's
individual.
always about the individuals.
Yeah.
It's always
but
about
who decides on the veracity of that risk?
you get an expert.
Yeah, but who decides? Who's watching?
Senwelo does.
Yeah, but
You get an expert.
who's watching the watches over here?
No,
How do
you
we
get
know
an
that-
expert
yeah.
to tell you that, okay, we have assessed the risk here,
Yeah.
and then we realize that the risk is going to be too high. The issue is always, to what extent is it going to affect the fundamental rights and freedoms of persons? And fundamental
Right.
rights, we mean the right to privacy, we mean the right to freedom of expression. The freedom of expression, really, not the right to freedom of expression. We mean the freedom of association. So those fundamental rights in the Constitution, if at all, should anything happen, should those be impacted, then you have to notify before doing anything.
Well, that's Stencil TV for you today. Thank you for joining us, and we will see you next time.